Heyo, it is Friday, and today is the deadline of the state's replies to the defense motions. I will address most of them in tonight's stream, or this afternoon stream, starting at 6 p.m. Eastern, if you are watching this on July 26. Now, the one I want to address here is Yak Gotti's attorney, Doug Weinstein, is replying to Prosecutor Love's motion to silence the defense. She wants to shut up the defense, make the court tell the defense attorneys to not speak to the public. Oh, Doug Weinstein, you beast. Welcome to the show, folks. All right, let's start. In the Superior Court of Fulton County, State of Georgia, Diamante Kendrick. Kendrick's opposition to state's motion to restrict extrajudicial statements. Comes now defendant Diamante Kendrick in the above-styled case in opposition to the state's motion to restrict extrajudicial statements, showing the court the following. Quote, everyone is in favor of free speech. Hardly a day passes without its being extolled. But some people's idea of it is that they are free to say what they like. But if anyone says anything back, that is an outrage. End quote. Sir Winston Churchill. Doug is quoting Churchill. Then he quotes somebody else here. Quote, I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and to not be held responsible, end quote. Fonnie Willis, Fulton County District Attorney press conference of August 29th, 2022. Yeah, I guess you all saw this coming. The prosecution, up until the trial started, released statements to the press constantly. Doug Weinstein continues with quoting, free speech for me, but not for thee, end quote, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like the present trial to be conducted in secret, where proceedings happening in hidden chambers outside the prying eyes of the press and the public. The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite this court order that such showing be demonstrated prior to blocking the broadcasting of witness testimony. Yeah, there have been cops up on the stand testifying that I don't understand what, all but maybe one who was still working as an undercover cop, that I understand, but the rest of them, seriously? Let's continue. After attacking the integrity of respective counsels for defendants and witnesses, e.g. repeatedly calling the Honorable Brian Steele a liar and accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland, the state now turns its attention to counsel for Diamante Kendrick. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think it's hell. In a 1.5-page motion, the state cites the Rule 3.6 of the Georgia Rules of Professional Conduct and cherry-picks certain comments to the rule to support its motion to, quote, Instruct the defense to refrain from making extrajudicial statements about this case moving forward." End quote. No case law is cited. No finely tuned order is proposed. As the state accurately quotes, Rule Point 6 bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of candidates' counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by candidates' counsel that might arguably violate Rule 3.6. The court should decline this invitation. Remarkably, again, I'm still a bit bummed out about me not being an exhibit in this in the state's motion. I have had Doug on my show 3 times, and I hope he will continue to show up. I love having Doug on. He's a hoot. Let's continue. Remarkably, the state does not make a single argument that any statement by candidates' counsel meets any of the elements of Rule 3.6. Instead, the state simply offers up a single conclusory statement. There is no argument that any statement by which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel find themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend the client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Here's Gentile v. State Bar of Nevada from 1991. Justice Kennedy also correctly notes that the police, the prosecution, other government officials, and the community at large hold innumerable avenues for the dissemination of information adverse to a criminal defendant. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense. And most criminal defendants have insufficient means to retain a public relations team apart from defense counsel for the sole purpose of countering prosecution statements. Justice Kennedy cites the important role that defense counsel plays in educating the public on pending cases, writing, because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent. This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him. Initially, by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him, And now, by holding press conferences, denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays that the court deny the state's motion. Yeah, this is regarding the rap lyrics George Glanville allowed in as evidence of crimes. And I remind you that Georgia Supreme Court has made a ruling this year, early this year, regarding the prosecution, how the prosecution is allowed to use lyrics and rap videos. I will try to find my reaction to that, and I will, if I find it, you will find it in the description to this video. Okay, this is the first of maybe a few videos I will do regarding these replies and motions today. But most will happen in the live stream at 6 p.m. Eastern Time today, Friday, the July 26th. Okay, folks. That is what I had for you at the moment. And as I always say, folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Thank you for tuning in. Have fun. Bye-bye.